Welcome everybody again to another live stream over here. And yesterday was a very big day. Yes, we had the Alex Murdaugh evidentiary hearing, which we've all been waiting for a while now. As soon as this motion was filed, we've been all waiting for this evidentiary hearing, which I already told you guys months ago, which is most likely going to happen. So it finally happened. We have this evidentiary hearing. And so just a few things. I know people probably have a number of different questions. So if you don't mind, anybody who is here on the live stream, if you can just wait till the end to ask those questions. Let's get through some of these clips. I'm going to try to show you some of these clips and some of my analysis and then some of my take on it. Some of you may already have ideas about what my take is going to be on some of this because of if you've been following, which you should be, then you're very well up to date on the law and everything. So we're going to jump into that in just 1 second. First, I just want to always, like I usually do, is make my disclaimer. I have no dog in this fight, and I'm not going to be talking about whether Alex Murdaugh is guilty or if he's not guilty. We're not going to be getting into the evidence, the actual evidence of whether he is guilty or not. That has really nothing to do with what's going on right now. But during this evidentiary hearing, this is all about a specific, discrete issue of jury tampering and what that means under the law, what's the standard, and whether the correct standard was applied, and different evidentiary things that came out during the hearing. So without any further ado, let's jump into the first clip. And I'm sure as everybody was watching this, if you were tuning in for the entire evidentiary hearing, you were probably blown off your seat as much as I was when the first juror comes in and already there's fireworks going on. The rest of the day was a little less exciting. Still some parts of excitement, but for most of the other jurors, it wasn't too exciting. But the first juror of the day, letter number Z, she gets in, and this is what we have. So give me a second to pull this up.
Juror Z, I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Now, you'll remember that we spoke about the proposed questions that the judge proposed to be asked, and the first question did not sound anything like that. And we said that, obviously these things can change, which I think was right. I think that it was the right decision to change that question. After all, the way that she proposed the question initially was, is that still your verdict today, which is in 2024, and really that has really not so much relevance to what they're doing here. So the fact that she changed it to, was that actually your verdict at the time, that was the right move, and I think that's a great way to start off. So let's continue.
Right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Now, I thought that was an interesting way to have the second question, because the second question really answers all the questions. It really answers all the questions. Was your verdict based entirely on the evidence and the law presented at the time of trial? So really, as soon as they answer yes to that question, there should be no reason for any further questions. The juror, after all, just said very clearly, yes, all of my verdict was based entirely, 100% entirely on the evidence and the law. So really, that should be the end of the inquiry. But yet, they ask further questions. So I question about whether that should have been the second question. I don't think it should have been. I think that they should have gone into more specific questions about leading up to that question first. But this is the order in which they did it. And so that was the question. But they're going to, even though the juror answered yes, they're going to continue to ask other questions of the conduct of Becky Hill. So here we go.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's
Well, you know what else there is, according to her affidavit, which I think is a little more significant than just watch him closely and watch his body language, is that in her affidavit she actually says that Rebecca Hill told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. I think that's pretty significant, but she forgot about that comment that Becky Hill made. But she did mention the other ones, and we're going to get into more about the affidavit later, but let's just continue the questioning for now.
fine. Was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that, that's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
And this is the point where everyone who was listening to this completely just fell off their chairs, because I did not imagine in a million years, once the judge decided what the standard was going to be, that you actually have to prove actual bias and prejudice. I did not believe that a juror is actually going to say that really affected her verdict. The fact, any statements that Becky Hill made actually affected her verdict. So once she says that it affected her verdict, I basically fell off my chair. I'm sure everybody else did also. And then at that time, you're thinking, wow, he's actually going to get a new trial, even though she really contradicted herself within these questions itself. As we said, the second question was your verdict based entirely on the evidence and law presented to you at the time? She answered yes. And now she's saying, well, her verdict was influenced by Becky Hill. So she's already contradicting herself within these questions itself. But that's not enough for the judge. So the judge is going to now pull out her affidavit. So she dismisses this juror for the moment, and she asks the attorneys, if they want to have any further questioning or any other comments they want to make. And they both, really it was the state's saying, well, she's got this affidavit, and the affidavit, let me show you what this affidavit says. So here we have this juror's affidavit. So the judge really goes through every single line of this affidavit and asks the juror about it. We're not going to play that all. But if you look, this is what number 3 said. If you look at number 3, which is one that I mentioned before. And then, well, actually, there's 2, which says not to be fooled. 3, again, says watch him closely, and then which I understood to mean that he's guilty. And then we get to number 10. Here's number 10. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Now, the question that really you could be asking is, did the attorneys actually review this affidavit? Because the attorneys understand, or they should understand, they should know that this statement really has no bearing on anything. Because if you're pressured by other jurors, that's exactly what the point of deliberation is. Not the point, but that's what happens in deliberation. You can feel pressured by reason, you can feel pressured by logic, you can feel pressured by evidence. So this paragraph really shouldn't belong at all. So this was done, this looks like it was drafted, I mean, at least it was signed by Holly Miller, who is the paralegal, one of the paralegals who worked on this case. But this question, which ended up being the sticking point here, I'm sorry, this paragraph, this line number 10, which I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. This one's going to become, or became, a real issue. So let's jump ahead to where it became an issue here. So let's get rid of that. And we'll go ahead to 30.
Juror Z, I asked you previously, was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you.
All right. Well, there you have it. So she asks her, she presents her with this seemingly contradiction between her affidavit, which she says that her verdict was only pressured by the other jurors, and her statement that her verdict was influenced by Becky Hill. And she asks her which one is, well, she doesn't ask which one's more accurate. She says, is the affidavit more accurate? And the juror says yes. Well, now it seems that the juror seems to be taking back what she said. So is that really what's happening or not? Well, we do have an objection to deal with. Let's just remove this for a second. We do have an objection to deal with because Arpitulian objected. He objected and he said objection as to form. What does that mean, objection as to form? Objection as to form is that he doesn't like the form of the question. The way that the question is being asked, he doesn't like the way that the question is being asked. And does he have a point or not? Well, I think he does have a point. Number one, he has a point because the question, the suggestion of the question is that there's a contradiction between the affidavit and what she said earlier, that Becky Hill influenced her verdict. And the way that she's asking the juror is that which one is true? Is the affidavit true, or is what you said true? Now, this could be a common way, common practice of cross-examining a witness. If you're on one side and you want to make the witness look like a liar, you try to do such a thing. But really, you have to think about it. And again, the judge is not being a lawyer here. The judge is really just seeking the truth. So the judge really is not employing any cross-examination techniques. She's supposed to be just looking for the truth. So is this a contradiction or not? And the answer is it's not a contradiction because both can be true. Can both be true? Can it be possible that Becky Hill influenced the way that this juror observed the evidence, the way that this juror thought about the trial, the way that this juror was processing the information and thinking about the information, and did it play on this juror's biases about whether the guilt or innocence of Alex Murdaugh? And that could be true. Yeah, sure, it did play into effect. And now you have this juror who is on the fence. On the one hand, she has certain feelings about maybe his innocence, and then on the other hand, she has this whispering in her ear from Becky Hill saying, well, we really think that he's guilty. And now it could be that she's on the fence. And because she's on the fence, now when she's in the deliberations, she gets pressured by the other jurors to vote in a certain direction. And if Becky Hill would have not spoken to her then perhaps she wouldn't have been pressured by the other jurors. She would have been much more steadfast in her convictions of his innocence, possibly. So the first suggestion, the first implication that this question is that there is a inherent contradiction between the affidavit and what she testified to, I guess we can call it testimony, what she testified to about Becky Hill's influencing her verdict. It's not a contradiction at all. So that's number one, why it's a fair objection to form. It suggests something that's not there. That's number one. Number two is that the form of the question could be objected to and it could be improper because it's suggesting an answer. And this really gets into a little bit more of a gray area where the question is whether something is considered a leading question. A leading question generally is a question that suggests an answer. You're kind of suggesting a certain way that you want the witness to answer a question. So on cross-examination, the rule is that that's allowed. On direct examination, that's not allowed. So this is where we see this play out in an actual courtroom. So the question that we can ask here is this question a leading question? Is this question by the judge showing the juror that the judge wants this juror to answer the question a certain way? And you can argue about this both ways. I'm not saying that it's clear from the question one way or the other. She did say, and I'm just going to give you the argument, that the argument is that she said, is this affidavit more accurate in your feelings that day? So it's like you're suggesting, is this more accurate? Come on, I'm sure it's more accurate, right? It's more accurate, right? So instead of saying, real cross-examination would sound like this affidavit is more accurate, isn't it? Right? So that she didn't do. But does this kind of push the witness or the juror in this case to answer in the affirmative that yes, the affidavit is more accurate to how I felt at the time? And is there any other ways that you could frame the question in a more open-ended way? And yes, I think that there could be a way that you could have asked the question a little bit more open-ended. And it could be also, by the way, it would have been certainly appropriate if she would have said to the attorneys, I would like to ask the following follow-up question. Do you have any opinions about this before they ask this juror, before she decides to ask the juror this question? That happens a lot of times during jury selection. The judge will say, okay, this is what I want to say to the jury. Do any attorneys have any problems? And then, you'll make your record at the time. But that didn't seem to have happened here. Now, could there have been another way to ask this question? Yes. I think she could have asked a question like this. Which one is more accurate? Assuming there is a contradiction, which I don't believe there is, but let's just go into her mind. And she says she thinks that this is a contradiction. So then you could have asked the juror, well, juror, you have the affidavit and you have what you said before. Which one is more accurate? Not, is this one more accurate? So that's a little bit more of a little bit more of an open-ended way to ask the question. And also another easy way to ask the question is to tell the juror, well, can you explain this? Because on the one hand, you have the affidavit that you're telling me, you weren't influenced. On the other hand, you told us this. Can you please explain to me what your feelings are? So that would certainly, I think, be a better open-ended way to let the juror speak their mind. If you're seeking the truth, it would have been a better way, I believe, to ask the question instead of, is this more accurate than what you just said a minute ago? So a fair objection, I think, that he made, and it doesn't matter because the judge didn't really care. And again, the follow-up question was, so you stand by your affidavit? And she says, yes. Again, like I said in the beginning, you could stand by your affidavit and still it's not a contradiction to what you said that Becky Hill influenced you. So this juror actually herself filed another affidavit. And let me show you this affidavit. So here is this affidavit of the juror. And here she's saying, I would like to clarify my testimony today. As I testified, I felt influenced to find Mr. Murdaugh guilty by reason of Ms. Hill's remarks before I entered the jury room. Once the deliberations began, as I stated in paragraph 10 of my earlier affidavit, I felt further additional pressure to reach the guilty verdict. So essentially saying how both can be true. And this is what she files in her affidavit. And we saw that there was some discussion about this with the judge, but the judge did not allow this affidavit in. Perhaps it was proffered. I know it was filed, but we don't know, it didn't seem like it mattered to this judge. The judge said, we're not going to allow to call the witness again. Once the witness is done testifying, we don't call the witness again to clarify things. So she did not, the judge did not seem to take this affidavit into consideration. So, but there you have it. It's like I said, I think it's pretty clear that it's not an inherent contradiction, and both can be true. And I think that the question could have been phrased a little bit better. All right, now let's move on a little bit to her finding in this case. And we understand, we already know a little bit about how what standard she's using in this case. But let's just play a little bit about what which standard she's applying and part of what she's saying about that. This is
factually argue this is, we did not understand, we assumed you'd adopt Remmer because that was.
Well, I don't know why you assume that, when
Because
the
that's
South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of U.S. v. Rimmer.
We do not believe that's what Justice Kittredge has said.
He said it straight out, as clear as a bell can be, but I ruled.
So you see that he said it straight out, as clear as a bell could be, that we do not go with Remmer. That's what Justice Kittredge. Justice Kittredge is the author of State versus Green's opinion. He is the author of this Supreme Court opinion in State versus Green, and she is saying it is clear as a bell. We're just going to take a look at this soon. It is clear as a bell that he is not going with Remmer, which means that South Carolina is not going with Remmer. Now let's go a little bit further.
Dismissed from further service.
Now this is where she's coming to her actual conclusions and rulings and her findings.
The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict. Citing.
So there you go, that it has to actually influence the juror. You have to prove bias.
State v. Green, State v. Aldred, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases.
So here she's saying that the defendant's position is that as long as they show that an inappropriate comment was made to a juror, so that automatically requires a new trial. And she says for that proposition, they rely on United States versus Remmer. Now, that's incorrect. That's not what United States versus Remmer stands for, which is why you start questioning about the legal analysis that this judge is doing. That was State versus Cameron. We spoke about State versus Cameron. State versus Cameron said, if there's any inappropriate comment about the merits of the case, so then that automatically is going to require a new trial. And I spoke about how the defense wanted to use that case and they're arguing that case, and I felt that was, first of all, I don't think that was decided appropriately. I think that's wrong, and also I don't think that as strategy for the defense they should have argued that case. You can kind of mention it to show how far the courts go to protect defendants, but I don't think that they should have made that their main argument. I think their main argument should have been United States versus Remmer. But here you see that the judge, this Justice Toll, is conflating United States versus Remmer with State versus Cameron. So that is not what United States versus Remmer stands for. United States versus Remmer stands for the proposition that once a comment is made about the merits of the case, now there's a presumption, a prejudicial presumption of prejudice, and now the burden shifts to the state. But we'll continue anyway.
My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influence the juror to vote to convict defendant Murdaugh.
Okay, so basically, as we all know, she's going with the state's understanding that you have to actually prove prejudice. The defendant has the burden to prove prejudice, and the defendant has the burden to prove bias. Okay, now let's just finish this up, and then we're going to discuss all of this. We'll go to her ultimate conclusion here.
Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous.
So one juror was ambivalent on her testimony, meaning she was contradictory in her testimony. So that again goes back to our original point that really it's not contradictory at all. Let's continue.
Affidavit in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject.
But she forgot to study my channel. Then she would have really understood. But let's continue.
Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered.
All right. So that is her ruling. Motion denied. And if you want, you can appeal me. That's essentially what she is saying there. Now, I do want to make one point, and we're going to go back to, the basis for her ruling is that she understands the case law and she has studied this case. And she actually said that she has been a lawyer for 20 years and 35 years as a Supreme Court justice. And she read the whole transcripts, all the transcripts of the trial, and she studied this. She looked at the case law. She looked at those treatises and scholarly articles. And this is how she comes out that South Carolina, the jurisprudence is that you have to prove actual bias. And as she said earlier, Justice Kittredge in State versus Green, it's clear as a bell. It is just clear as a bell that he is saying that we do not go by Remmer. So let's just back up for a minute, and then we'll get into the actual case. I'm going to show you some clips from the actual case. We have two different ways to deal with jury tampering. There's State versus Remmer, and there's a Smith versus Phillips. State versus Remmer, as we all know, says that as long as you prove that there's been a communication, so now there is a communication about the merits of the case, let's just say, so now there is a presumption of prejudice. Now the state has the burden to prove that that communication was harmless. That's State versus Remmer. Smith versus Phillips says that the defendant has a burden to prove not only that there was a inappropriate communication about the merits of the case, but also that there was actual bias, there was prejudice. So that's what they have to prove. That's Smith versus Phillips. That's State versus Remmer. And now the question is, well, what should the states, remember this is in the United States Supreme Court, which is in the federal system. What should the states do? A state like South Carolina, what should they do about this? Should they go with should they go with Remmer, United States versus Remmer, or should they go with Smith versus Phillips? What should they do? So I do want to say the following, that in South Carolina itself, there is a split. In the Supreme Court itself, the actual Supreme Court has, in South Carolina's many years of jurisprudence, has published opinions which take both ways. They go with Smith versus Phillips certain times, and certain times they go with Remmer. So you have to concede that point. That is true. For example, there's a case called State versus Grovenstein. State versus Grovenstein, which is a South Carolina Supreme Court in 1999. And this is what State versus Grovenstein says. It says the following: we have consistently required defendants to demonstrate prejudice due to improper jury influences. So here's State versus Grovenstein. The South Carolina Supreme Court saying that we have consistently required defendants to demonstrate prejudice. It's not enough just to demonstrate that there's been inappropriate communication with a third party and a juror about the merits of the case, but also that you have to demonstrate prejudice. So you have State versus Grovenstein. It's black on white, showing clearly that you have to show prejudice. And there's also another number of other cases that they quote. You can take a look at this case yourself, State versus Grovenstein. But then we have State versus Green. And this is what the judge is saying she's relying on. She's relying on State versus Green. And she even tells Harper Dillon, I didn't play this clip, but she even tells him that if the Supreme Court wants to modify State versus Green, they can do it. But she understands that State versus Green is how that is the prevailing opinion. That's the prevailing ruling and holding of South Carolina. So let us, and why is that, by the way? State versus Green, why should that be more persuasive than State versus Grovenstein? And one of the reasons is that State versus Green is a 2020 case. So when you have a Supreme Court case in your jurisdiction, and it's an earlier one, and then you have another one, which is later in a 2020 case, which one do you think you should go with? Should you go with the 1999 case, or should you go with the 2020 case? And the answer really is, generally speaking, that you go with the more recent case. The more recent case is the one that's actually talking about the situations that arise in our world. So that's why you should go with the State versus Green case. So that's what this Justice Toll is doing. She's going with the State versus Green case. So now let's take a look at the State versus Green case. We have Justice Kittredge, who's saying clear as a bell that we go with Remmer. So here we go. So this first is the Court of Appeals. So just to be fair, this is the Court of Appeals case. So State versus Green started out at the trial court level, and then it got appealed to the Court of Appeals in South Carolina. And this is the Court of Appeals in South Carolina giving their opinion about what they feel about Remmer. So let's start, and this is what I highlighted. In the event the trial court learns of an allegedly improper contact with a juror, the procedure of Remmer versus United States must be followed. It's not an option. It's not, well, we can choose whether Smith versus Phillips versus Remmer. This is the Court of Appeals in the South Carolina saying that Remmer versus United States must be followed. And then continue down. Look what it says. It just quotes Remmer. And then it says the following. The scope and currency of the Remmer's presumption has split to federal circuits. As we've discussed in our previous videos, that is true. Whether Remmer is still good law has split the federal circuits. But it remains alive and well in the Fourth Circuit. Well, you know what state is in the Fourth Circuit? South Carolina. And therefore, now this is the Court of Appeals talking, and therefore controls our approach to the Sixth Amendment issue Green raises. So we are controlled. This is what the Court of Appeals in South Carolina is saying. We are controlled by Remmer versus United States. This is them completely injecting Remmer versus United States into the jurisprudence of South Carolina. We are controlled. Our approaches are controlled by them. And then continue. Look what it says. Continuing down. When there is evidence of a substantive communication by a third party with a juror, the Remmer presumption applies, shifting the burden to the state to prove there is no reasonable possibility. And look at those words. There is no reasonable possibility the improper communication influenced the verdict. So if you have a reasonable possibility, is it possible? Not does it have to be, but is it possible? You have a reasonable possibility that the improper communication influenced the verdict, which means if, let's say, you have a juror that says one thing and then you present them with an affidavit that says another thing. So now you say, well, which one do you go with? And then they say, well, I guess the affidavit sounds a little bit more accurate. Well, you still have a reasonable possibility. You have a juror that said under oath that she was influenced. So do you still have that reasonable possibility that the improper communication influenced the verdict? Even if you have this contradiction, and even if the juror gets rehabilitated and says, yeah, I'm going to go with my affidavit, that juror still said under oath what she said, that she was influenced. So is it a reasonable possibility? Well, under State versus Green in the Court of Appeals, I would argue that, yeah, it would be a reasonable possibility. Now, that is the Court of Appeals. So now you'll say, okay, well, this all got changed. This all got changed. This is all what the Court of Appeals mistakenly thought. This is what they all mistakenly thought. And then came Justice Kittredge and rang the bell and said, no, this is all garbage. We don't follow Remmer. We follow Smith versus Phillips. We follow a completely different standard. So forget about all this stuff about Remmer. Forget about this reasonable possibility. So let's take a look. Well, here says the following. There was no reasonable possibility the bailiff's comments influenced the verdict. So here they are saying that there was no, this is what they're talking about with the Court of Appeals. So this is, again, we have that same language, the reasonable possibility. And that was where the bailiff said that they may give the Allen instruction. Okay. And then look what they say. Look what they say. Our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. So let's read that again slowly. Our unwillingness to categorically apply. What does that mean, to categorically apply? That means that we're not willing to always apply Remmer. We're not always going to apply Remmer. We're not going to categorically apply Remmer, right? But what does that mean? That means that we are still going to apply Remmer when it's relevant. But for some reason, we're not going to always apply Remmer. And why is that? So let's continue down. And this is Justice Kittredge, clear as a bell, saying that he's overruling the Court of Appeals and saying we're not going with Remmer, right? It's very clear from here that we're not going with Remmer, isn't it? So let's continue. The attempted bribery of a juror in Remmer, conduct which goes to the heart of the merits of the case on trial, is a far cry from the circumstances presented in this case. Now, let me ask you, why do you have to distinguish? If you're overruling Remmer, essentially, if you're saying we're not going with Remmer, so you don't have to start distinguishing when to apply Remmer, when to not apply Remmer. You say we're done with Remmer. take Remmer and throw it in the garbage. That has nothing to do with South Carolina jurisprudence. We are clearly overruling Remmer. We're not going with Remmer. We're creating a new standard. And that standard is more in line with Smith versus Phillips. But that's not what Justice Kittredge does. This is Justice Kittredge. So Justice Kittredge is saying that he's making a difference. He's distinguishing Remmer and the situation in this case. The bailiff's actions here, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. So very clearly, what Justice Kittredge is saying is that Remmer is not invoked. It's not triggered when you have just a simple procedural question. But if you have conduct that goes to the merits of the case, like it did in Remmer, then we would apply Remmer. So again, we're not categorically applying Remmer. We're not saying that Remmer applies to every single communication that ever could occur between a bailiff and a juror, and automatically it triggers Remmer, and then you have to have a hearing, and then the state has a burden. No. Slow down. Calm down. Hold the horses. Okay? If it's a procedural question, let's not get too excited. Okay? That has nothing to do with Remmer. Remmer is when it talks to the merits of the case. And that is like so clear from this decision that Justice Toll is been a Supreme Court justice for 35 years. And she read this opinion and said that it's clear as a bell that Justice Kittredge is saying that we do not follow Remmer at all. Remmer's out. So again, it just leaves me scratching my head. So let's get into the actual. I'm just going to finish up here, and then we'll take some questions. Let's get into the question now, which is the appeal. So there's going to be an appeal filed. So the first question is, what's the standard of judicial review? And for every appeal, when you appeal to a higher court, so now, again, Justice Toll was acting as the trial court level. They're going to appeal it to the Court of Appeals, and then they may get appealed again to the Supreme Court of South Carolina. So the question is, what's the standard of review? And when you have a reviewing court, the court has to know how to judge the actions and conclusions and opinions of the lower court, the rulings of the lower court. How do you look at those rulings? How strict do you have to be? Well, when it comes to granting a new trial, South Carolina is very clear that it's reviewed under the standard called an abuse of discretion, which means that if the Court of Appeals finds, or the Supreme Court, if it gets there, finds that Justice Toll abused her discretion, then they can vacate what happened and then order a new trial. Okay, so that is the standard. It's a very high standard. It's extremely, extremely high standard to get. Abuse of discretion. So what constitutes an abuse of discretion, right? Don't you want to know that? So I'm not going to guess. I actually looked up the case. So the South Carolina Supreme Court has said in a number of different cases that an abuse of discretion occurs when the trial court's ruling is based on one of two things: an error of law, or when grounded in factual conclusions without evidentiary support. So two separate things. An error of law. So let's discuss that first. Was Justice Toll's findings based on an error of law? So you all think I'm going to answer yes, right? Because she misunderstood State versus Green. Not necessarily. Not necessarily. Because even if she misunderstood State versus Green, but if the Court of Appeals decides that, jurisprudence in South Carolina should not follow State versus Green, they should actually follow State versus Grovenstein, and a lot of other cases which say that actually the standard that Justice Toll applied should be the standard that we apply, and we should not go with Remmer. So even if technically, let's say she was wrong about State versus Green not going with Remmer, but there are certainly other cases that don't go with Remmer. And if the Court of Appeals finds that that is the correct standard, well, then there's no error of law. Even though you're right, she didn't get State versus Green right, but still, if the way to the law in South Carolina should be the other way, then should be the way that she said it, even though it's not straight State versus Green, it's not an error of law. So that's number one. But if the Court of Appeals agrees with Justice Toll that you should follow State versus Green, after all, it's a 2020 case. It's a very recent case. And they actually read State versus Green, like I did, and they see very clearly that they're not overruling Remmer, then that's where this could be an error of law. And since it's an error of law, there could be an abuse of discretion that's found. So that's when it has to do with an error of law. What about factual conclusions without evidentiary support? So that would be, again, this really all hinges on Juror Z's testimony. Juror Z said that she was influenced. But then afterwards, she said that the affidavit does more accurately reflect her feelings. So she did say that. So is there evidentiary support for Justice Toll's conclusion that that juror was not affected, not influenced by Becky Hill? I think there is evidentiary support for that, even though we don't like the questions and she could have asked it differently and they don't necessarily contradict each other and all the arguments that we made. But under an abuse of discretion, you have to find that there's no evidentiary support at all. And here there is evidentiary support. After all, she was presented with her affidavit. She said that she was only in the affidavit. She said that she was influenced by the other jurors. She was pressured by the other jurors, and that's what led to her conclusion. And therefore, can you make an argument that there's no evidentiary support at all for Justice Toll finding that that juror was not affected by that by Becky Hill's influence? I think that you have to find that. You have to find that there was evidentiary support. So I think it's a lot harder to prove that abuse of discretion as opposed to the abuse of discretion, which is an error of law. And again, that's going to depend on whether the Court of Appeals adopts versus State versus Green. If they adopt State versus Green, then there's a good chance, or there should be a good chance, that the wrong standard was applied, and therefore it was an error of law. But if they don't adopt State versus Green, then, and they say, no, that actually the other standard was correct, even though Justice Toll made a mistake and thought that that was State versus Green, but still, ultimately, there was no error of law there either. All right, so that's it for my part. Let me see if there's any questions. Please put them in the chat. And I'm just looking now, so just put them in the chat right now so I can address them now. So if you asked the question earlier, I haven't been seeing them. So let me see. Monique Dawn, what do you think of Becky Hill's behavior? Juror Z. Well, Becky Hill's behavior was as expected. She denied everything. It was brought out pretty clearly that she was impeached on a number of different things. Did she come off arrogant? Did she come off like she's trying to hide something? I think you kind of felt that she was hiding some things. I think it was kind of as expected as I was expecting. Yeah, she didn't do anything wrong, and she was as clean as the pristine snow. But I wasn't overly surprised by her demeanor. But again, she was pretty badly impeached. Juror Z, I would have liked to see more questions because I think she seemed to have been very confused, and it probably would have been very helpful to ask some more questions. I don't think she understood or realized, the gravity of everything, and I think it could have been helpful to have some more questioning for her, lay more foundations, just to get her, to help her. But we didn't get to see her. I just heard her answers, and like I said, some of the questions and answers didn't add up always. So that's what I have to say about that. Trish. Oh, I guess that's for somebody else. All right. Again, Monique. So it seems like a lot of juror issues lately, possible tampering, not following rules. Should there be tighter restrictions somehow? We addressed this earlier in other videos, and it seems like this issue is coming up a lot. So with social media and channels like this explaining the law and explaining the process, and really, if a juror would be tuning into my breakdowns and explanations, they would be a lot better and be much more better situated to make a decision. But they're not allowed to do that. You can't. So are things going to change? It's possible. Things may change as we continue, and as these issues keep cropping up. It could be that they'll crack down on these things. Maybe they'll crack down on how they're going to. Maybe they'll sequester more juries. Maybe there's a bunch of different possibilities. But you keep seeing this coming up, and it's got to stop. And the justice system is going to have to do something about it. So yeah. Is Justice Toll a male, female, or others? Looks like a woman, sounds like a guy. She is a woman. Here's an interesting question. Would the appellate court look at the judge's unwillingness to bring juror Z back for questioning by Harper-Tullian about her ambivalence? After all, the judge put the burden on him. They'd have to make this a point on the appeal. I know that Harper-Tullian did request that, so he placed his objection on the record, so it is preserved. They certainly can bring that up, that she was not allowed to explain more about her position. So, yeah, I think that the appellate court could look at that, and whether that's going to be considered an error, they're going to have to come up with some case law or some reasons why the judge made an error, and whether that again amounts to what would be an abuse of discretion. But again, it's coming back to the abuse of discretion issue. I think that's more the issue, whether it's an abuse of discretion for the law, the clear error of law, or the facts not based on evidence. So I think that's really what it's going to come down to. I'm sure they'll throw everything but the kitchen sink at the appeal, though. Jamie, I'd like to know what Juror Z's definition of influence. Doesn't that matter? Yeah, I mean, I don't know what she understood. I got to be honest with you. I don't know what she understood the questions to be. And all of this could have been explored by questioning from the judge. But the judge felt that she understood it. Actually, it's funny because one of the issues that first came up was whether the judge should be asking whether it influenced, whether the discussions were on the merits of the case. I think the question whether merits could be understood by the potential jurors. They didn't have any issue with influence, but it's possible she didn't. So, that certainly could have been explored. It probably should have been. Monique, again, what are the chances of case overturned on appeal for new trial? Slim. Again, abuse of discretion is very, very, very high burden. It's very difficult to prove. She does have case law on her side that goes with that standard. And like I said, there is what I would argue is evidentiary support for her conclusions. So it's not a foregone conclusion. It's going to be tough. Wendy, how far do you see this case moving up the line, so to speak? It's probably going to go all the way up to the Supreme Court of South Carolina, one way or the other. Whether the Court of Appeals finds an abuse of discretion or not, I mean, if the Court of Appeals finds that there's no abuse of discretion, it's certainly going to go up to the Supreme Court. So, and if it does, which legal scholars would appreciate, if it goes all the way up to the Supreme Court, and the Supreme Court actually it does what it's supposed to do and analyzes the two contradictory standards and says clearly for once and for all what South Carolina is going to be doing with this split. But the first thing is they have to acknowledge that there's a contradiction. That's the first thing, which I didn't see happen in South Carolina. They're just either choosing one or the other. I did see in other jurisdictions where they do choose, they show that there's a contradiction, and then they say what they believe, their jurisprudence should follow. But that should happen. I would like to see that happen. I mean, I think a legal scholar would like to see that happen. Have them button this up. Monique, it's the judge's discretion to overlook certain case law, Remmer, in favor of other case law. The judge is supposed to use the case law that they feel is the most persuasive. So if you have an issue like this where there's cases going both ways on an issue and it hasn't been solidified by the Supreme Court, then yeah, I mean, you might be stuck with just whichever case you want out of it. So these are like matters of first impression. The judges do the best that they can using whatever case law makes sense to them until they have a clear decision by their Supreme Court. Christina, although the cost of retrial would never outweigh the law as a deciding factor for granting a new trial, are there situations when the judge does consider costs when ruling? I would hope not. I would hope that is not the consideration in the slightest. Taya. Doesn't it seem that the judge is really saying that apart from the issues introduced by Becky Hill, she finds the evidence presented in court to be very compelling, so she judges the verdict to be valid? I thought, to be honest with you, that I don't know why she said that. She mentioned, if you were watching this hearing, she mentioned that she felt that the verdict was right. She felt that the jury got it right, that he was guilty beyond a reasonable doubt. And I don't know why she felt that she needed to say that. It actually rubbed me interesting. I don't know why she felt she said that, but that should in no way play into her decision here. You know, the whole question here is whether there was jury tampering, whether it influenced the juror's verdict. So whether she feels from the record that the conviction was correct, that should not have been her consideration for denying the new trial. Okay, well, thank you everybody again for joining. And if you haven't yet, subscribe, like the video, and we will see you next time.